Notice I call up H.R. 4711, the Remove Act, for purposes of markup, and move that the committee reported favorably to the House. The clerk will report the bill.
H.R. 4711.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Texas, Mr. Nels, for an opening statement.
Thank you, Mr. Chairman. Today, we are living in a new era of American history, a golden age under President Donald J. Trump. There is peace in the Middle East. American businesses are thriving. The economy is roaring. Law and order has been restored. The border is secure, and immigration laws are being enforced. God bless Donald J. Trump. Our allies respect us. Our enemies fear us. Criminals and terrorists and other bad actors recognize that they have no safe haven here, especially the bad hombres on the drug boats in the Caribbean. People around the world know that they can no longer exploit our laws, cross the border illegally, take advantage of the American people, and be rewarded with long-term residence in the United States. This is all a far cry from the absolute anarchy unleashed on the American people by the last administration. 2021, Joe Biden, Kamala Harris rolled out the red carpet for the entire world, opened our borders, watched terrorists, criminals coming in, terrorists, gang members, everybody coming into the United States. Come on, we're open. We predicted the results, even here in this committee. The Democrats were silent, or even worse, they were cheerleading the systematic destruction of our borders. When the Republican called out these obvious insane policies, Democrats accused us of racism and xenophobia. They said we were fear-mongering. When we proposed legislation to fix the problem, every single Democrat voted no. They voted no. The consequences were expected. Crime and destruction and chaos reigned supreme. After 4 years of Democrats' open borders, the American people were fed up. In a historic election 1 year ago, the American people spoke loud and clear. They elected Donald J. Trump and Republicans in the House and in the Senate on a mandate to make the immigration system work for America first. In 11 months, President Trump fully secured the border and actually began to enforce the immigration laws. Think about that, enforcing our nation's immigration laws. There's a lot of work still needs to be done. Millions of illegal aliens remain in the United States. So consider this. 3 months before the Joe Biden took office in 2021, the immigration court case backlog was 1.5 million cases, 1.5 million. After 4 years of border chaos and complete lawlessness, that backlog exploded to 4.2 million cases, nearly tripling in just one presidential term. That backlog is a direct consequence of the Biden-Harris border crisis. As the border crisis raged, the immigration courts received 1.2 million new cases in fiscal years 23 and nearly 1.8 million new cases in fiscal year 24, compared to 1.9 million new cases received from fiscal years 2015 through 2020 combined. The backlog is a key part of the Democrats' open borders plan to ensure that illegal aliens can remain in the United States indefinitely. That's what they want. Practically speaking, what does that backlog mean? It means that an illegal alien remains in the United States for years as they await a hearing before an immigration judge. Of the asylum cases that were adjudicated in fiscal year 23, only 14% resulted in an asylum grant, and only 12% of asylum claims granted in fiscal years 2024. So 12 and 14%. The other 80% coming over, they have no claim. They're just coming over. They're coming over and they want to stay here. They have no claim. Despite this, doomed cases languish in immigration courts for years, which incentivizes aliens to file frivolous applications, as they know they can remain in the United States for years and years to come. Who wouldn't take advantage of that stupidity? Well, millions have, and the American people are paying the cost. Just ask the families who have died at the hands of illegal criminal aliens, including those that are driving commercial trucks in our highways. Makes no sense. According to Democrats, if a foreign national stays in the United States illegally long enough, they suddenly become too sympathetic to deport. We're already hearing this rhetoric about aliens who came into this country during the last 4 years. They've lived and worked here for years, Democrats say. Well, of course they have, because Joe Biden let them all in and then didn't deport anyone for years. To my Democrat colleagues, let me make this very clear. An alien living illegally in this country for years doesn't mean that alien gets to stay here forever. It just means they should have been deported sooner. Should have been deported sooner. That's what this bill does. The Remove Act states that if you're here illegally, you must be placed in removal proceedings as expeditiously as possible. If you commit a crime that makes you more deportable, you must be placed in removal proceedings as expeditiously as possible. And once those proceedings begin, they must be completed within 15 days, 15. No more hanging out in the United States, committing crimes and taking advantage of public benefits for years while your fake asylum case is pending. No more gaming the system. You're an illegal alien. Your case is heard quickly, and if you don't have a basis to remain in the United States, you're deported, plain and simple. And that's what this bill does, and it's only common sense. Before Democrats falsely claim this goal is too lofty and too unrealistic, let me remind them about one of the Republican signature achievements from just a few months ago. Through President Trump's One Big Beautiful Bill, the nation's immigration courts are now flush. They're flush with cash. They are funding to hire immigration judges who can hear cases more quickly. The One Big Beautiful Bill also included new statutory fees for asylum applications and other commonly filed applications and appeals. Some of that revenue is directed back to the immigration courts. For maybe the first time in history of this country's immigration courts, resources are not the problem. This bill puts those resources to good use, America First use. Meanwhile, President Trump already has revived the failed courts after Joe Biden's destruction. President Trump's immigration court leadership finally empowered immigration judges to dispose of frivolous applications in which the facts clearly do not establish eligibility to remain in the United States. And we know that under Democrats' dream of open borders and limitless immigration, that immigration court proceedings aren't over until the alien wins. Imagine that. We got to do it in the ends when the alien wins. We're here to promote a different dream, one that prioritizes aliens with valid claims to remain in the United States and the American people. The Trump administration is already doing everything it can to ensure bad hombres are removed from America's streets. The bill gives the president yet another tool to deport illegal aliens quickly by speeding up the legal process. The Remove Act injects common sense into immigration system, and I urge my colleagues to support it. I yield back, sir.
Gentleman yields back. The chair now recognizes the gentlelady from Vermont, the ranking member, for an opening statement.
Thank you, Chairman Jordan. I'll be reading the remarks for our ranking member who is still on the floor. The Remove Act is yet another Republican bill aimed at stripping away due process for immigrants. The bill arbitrarily requires that all immigration court proceedings last no longer than 15 days. This is a fundamentally unserious idea, completely divorced from the reality of our immigration courts. It would result in an immigration court system that lacks due process protections and prioritizes speed over fairness and justice. Given the current state of the immigration court system, it is not humanly possible to properly and fairly adjudicate removal proceedings in 15 days. Immigration judges are already dealing with crushing caseloads. Forcing them to adjudicate cases on a sped up timeline will only result in mistakes and incorrect decisions and will deprive individuals of their fundamental rights to due process. Immigration courts have long suffered from inadequate resources and significant case backlogs, but these problems have only worsened in recent years. Since 2015, the immigration court backlog has more than quadrupled in size and now sits at approximately 3.8 million cases. The Trump administration is also firing many experienced immigration judges and is seeking to replace them with temporary and inexperienced immigration judges. At least 139 immigration judges and court personnel have reportedly been fired, transferred, or have taken buyouts since January 2025. As of July 2025, there are only 685 full-time immigration judges. Although, as my colleague from Texas claimed, the One Big Beautiful Act, you said it meant that we are flush with cash in the immigration court system. It does provide funds for hiring immigration judges, but it caps the total of immigration judges at 800, which is far short of the number that is needed. Experts estimate that it would take 1,300 immigration judges to work through the backload over the course of a decade. Moreover, immigration law is considered by many to be the most complex areas of federal law, second only to the U.S. tax code. Individuals in removal proceedings may have a valid legal basis to remain in the United States, but no way to properly articulate this to an immigration judge without the assistance of counsel. In fact, according to a University of Pennsylvania Law Review study, only 5% of immigrants who won relief from deportation in the time period of the study did so without the help of an attorney. Imposing a 15-day requirement on the completion of removal proceedings is akin to denying people their day in court, which violates our bedrock principles of fairness and due process. It leaves non-citizens with little time to find a lawyer and leaves lawyers with no time to competently prepare a case. Today, it takes an average of 4 years for non-citizens to receive an asylum hearing, and final decisions can take much longer due to appeals. Now, those averages are way too long. We need to find a way to speed up the process while ensuring that it is fair and equitable. We must be able to determine who's eligible under law to stay in the United States and remove those who are ineligible much more quickly. But this bill, which provides no resources, no plan, and no process, is not actually a solution to the problem that we have. And I do not doubt or question the intent of Mr. Nels in bringing forward this legislation. I think we share the goal of deciding these cases more quickly. But forcing immigration judges to decide complicated and consequential cases in a matter of days is not the answer. Rather, Congress should reform our immigration system and appropriate the resources necessary for cases to be resolved fairly, efficiently, in a timely manner. We also need to find a way to make immigration judges more independent. For far too long, immigration judges have been subjected to an ever-constantly changing set of policy priorities from both sides of the aisle and have not given enough protection from losing their jobs. Given the life and death decisions the judges have to make every day, we need to ensure they have the adequate independence to do their jobs. I hope my colleagues will work with us to address some of the areas where this bill falls short. However, at the end of the day, I think we need to start over with this one. I urge my colleagues to oppose this short-sighted bill, and I yield back.
Gentlelady yields back. Without objection, all other opening statements will be included in the record. The chair now recognizes the gentleman from Texas to offer an amendment in the nature of a substitute.
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment in the nature
Without
of...
objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purposes of amendment. The chair now recognizes the gentleman from Texas to explain the amendment.
This amendment makes technical changes to the bill and ensures aliens are placed in removal proceedings as expeditiously as possible. I yield.
Gentleman yields back. Who seeks recognition? Gentlelady from Washington is recognized.
Mr. Chairman, I have an amendment at the desk.
The clerk will report. Point of order reserved by the gentleman from Arizona.
Amendment to the amendment in the nature of a substitute to HR.
Amendment will be considered as read. The gentlelady from Washington is recognized to explain her amendment.
Thank you, Mr. Chairman. I want to be clear about something. Our immigration court backlog today stands at 3.8 million cases. It takes someone the better part of a decade to finally have their day in immigration court. And this bill, without investing any resources in changing that system to rid the backlog first, just overloads an already overloaded system with a ridiculous 15-day timeline. That's why my amendment would require the Executive Office of Immigration Review to have the necessary number of immigration judges and support staff in place to actually adjudicate all these immigration hearings before putting this absurd 15-day timeline in place, to at least try to ensure that this bill is implemented in a slightly more responsible way. We all know that the current backlog and wait times are way too long and unfair to the people who have legitimate asylum claims or other claims for relief. We all understand and agree that it doesn't make sense for people without a legitimate claim to be in the United States for years. And that is something that we would work collectively on with the other side. It's also why, when we were in the majority, Democrats tried to move legislation that would actually make the real structural reforms that our immigration courts needed to work. We advanced legislation that would make our immigration courts completely independent to take politics out of the system. We work to ensure that children have counsel so that they can navigate immigration court proceedings. No one wants to see children as young as 3 or 4 years old trying to defend themselves alone in any court. We fully funded the legal orientation program in detention, which actually makes our courts operate more efficiently by helping people better articulate their claims or even realize that they don't have a viable claim for relief. We need fair and orderly and timely adjudications of immigration court cases. Those are the kinds of reforms that we need to actually make the immigration courts function. But this bill does absolutely none of those things. Instead, it just places an arbitrary, unworkable timeline on all court cases. It is a completely unfunded mandate dedicating no actual resources to its implementation. Immigration judges face daunting caseloads. Over 100 judges have been fired or pushed out by the Trump administration, despite historic case backlogs. And we now have roughly 685 immigration judges, which is not nearly enough to handle current caseloads. It simply would not be possible for the existing number of immigration judges to handle adjudicating the cases in the backlog within 15 days from start to finish, let alone the new cases that are being added. So for this bill to be feasible, we need more judges. And in a cruel and harsh irony, that would likely require the Attorney General to waive certain provisions from the Republicans' Big Bad Betrayal Bill, which did cap the number of immigration judges at 800 starting on November 1st, 2028. But even that number, 800, would be woefully insufficient to carry out the requirements of this bill. None of this is the kind of thoughtful approach that we need. This is really the opposite. Even putting aside the unfunded mandate and the complete inability to implement this bill, it is the opposite of ensuring access to justice and due process. It's actually just bad policy. Remember that because immigration proceedings are civil proceedings, not criminal proceedings, there is no right to counsel in immigration proceedings. So just imagine that you are given a charging document that places you into removal proceedings. Under this bill, if you want to hire an attorney or find a pro bono attorney, you need to find one in a matter of hours. You need to figure out what form of relief you're going to apply for. You need to prepare for trial in one of the most complex areas of law in the United States, and you need to be prepared with testimony and witnesses before a seasoned ICE attorney. Under this bill, trials must commence, quote, as expeditiously as possible once the notice to appear is filed within the immigration court. And then you've got 15 days from the beginning of proceedings until the end. So to put this in perspective, the form to apply for asylum alone is 12 pages long. Asylum applications, which consist of affidavits, country conditions reports, expert testimony, primary source documents, and more, are often hundreds of pages long and can take months to compile. That's not to mention the trust that attorneys have to develop with clients to understand their relief claims. Imagine being a survivor of torture or sexual assault and having to relive all of that trauma with a total stranger in under 15 days. I sincerely hope my colleagues will consider accepting this amendment. It won't completely fix the bill, but it will go a long way to ensure that it's done in a somewhat more responsible way. I yield back.
Gentlelady yields back. Gentleman from Arizona is recognized.
Thank you, Mr. Chairman. I oppose the gentlelady's amendment. She
Withdraw
mentioned.
your point of order. I think you had
I'm sorry.
withdraw your point of order.
Yeah, I withdraw the point of order. I'm sorry. Move to strike last word.
Gentleman is recognized.
Thank you so much. And I oppose the gentlelady's amendment. She raised the specter of a 3-year-old going in to testify. Well, here's the way it works. If you were under the Biden administration, they would give you over to ORR. You'd be placed with an unvetted sponsor, never to be seen again. Over 400,000, according to the Office of Inspector General. 58,000 of them under the age of 12. They never made it to their court dates for that little child. Why? Because they'd probably been trafficked. So while we're justifiably concerned about what happened in the Epstein case, I find it intriguing that the Democrats never bothered to raise this this particular issue. It was always the Republicans. And that's when you actually had the ORR director come in to our subcommittee and admit she had no idea where more than 300,000 of those children were. She admitted that. But what happens now, which was supposed to happen then, is a guardian ad litem gets appointed to represent and manage the child's interest. That's what happens. So when you start talking about children, you better at least know what happens there. And so to support that, Mr. Chairman, I'll submit this article called DHS Inspector General, 448,000 unaccompanied kids transferred under Biden.
Without objection.
Thank you. Now, what else? What else has to happen here? Under the Biden administration, those of us who live along the border and spent many, many days and nights on the border talking to people coming in from over 165 different nations, from San Diego to McAllen. These individuals had no idea why they were coming other than they were told they could come in and receive basically life, a new life in America. That's what was happening. And the women were being trafficked and the children were being trafficked. And if you'd never seen rape trees, then you didn't get on to the border. You probably shouldn't be talking about this. It's real easy to talk about this stuff from off the border. It's not real easy to talk about it when you've been to the border and spend a lot of time on the border. And these folks, many of them coming in, literally millions and millions, which is why you have a backlog that went from about 1 million to 4 million. That's your backlog. And the reason that that's happened is because the previous administration let the world in and told them. That's why if you went over to Tijuana, you'd see in the square right there in the Zocalo, you're going to see people wearing "Let Us In, Joe Biden" t-shirts. That's what happened. And these folks should be removed. You actually have more than 1 million people, probably about 1.5 million now, who actually have removal orders. But we've lost them. We've lost them. The Biden administration had like 1.2 million, and they didn't remove them because they said, well, you know, whether you have a removal order or not, we're not going to remove you. In fact, the Secretary of DHS at the time said, just because you have a removal order, if you don't have some other serious crime, we're not going to remove you. That vitiates the rule of law and undermines our sovereignty and undermines the very notion of a nation state. That's what happened under Joe Biden. I view what Mr. Nels is trying to do here as simply trying to move this thing forward and acknowledge that you have a major problem and these folks who have come here illegally, and that is the term of art, they are illegal aliens, should be removed and should get their process as swiftly as possible, and then they can go back to their home country. With that, Mr. Chairman, I'm going to oppose this amendment. Yield back.
Gentleman yields back. Question occurs on the amendment offered. Gentlelady from California is recognized.
Thank you, Mr. Chair. Lord have mercy, what a day. So I do support the amendment, and I'm going to yield some time to my colleague from Washington State. But first, I just have to say we're talking about, I think, girls on the border and being trafficked. And I guess I represent a border state, California. And we have a corridor in my district called the Figueroa Corridor, where teenage girls, as young as 11, are being trafficked on the streets in all kinds of inappropriate wear, and sometimes not hardly wearing anything at all. And they're being trafficked by these pimps to pedophiles who are knowingly having sex with 11-year-olds and 12-year-olds and 13-year-olds and 14-year-olds. And sometimes they're girls and sometimes they're boys. And most of them are from the foster care system. And I'm gonna tell you something else. We have AUSAs, we have DAs that have been trying to work on getting rid of these traffickers, trying to help these young girls and young boys, trying to get rid of the prostitution and the trafficking happening on the corridor. But you know what's happened? Department of Homeland Security and Kristi Noem have called off these AUSAs and these DAs from working on these cases because they don't care about these girls. They want these people gooned up, running into churches, running into kindergartens, snatching parents and kids and detaining them unlawfully to deport them because somebody is looking for a TV show of terror. So I don't need nobody today talking to me about how we need to be trying to help some victims when you have prosecutors who've been working on these cases for years calling our office saying, can you do something? Because the case I've been working on, and I'm about to get these bad guys, I've been called off of because Homeland Security needs another TV show coming out of MacArthur Park. So give me a break. And with that, I will yield the rest of my time to Congresswoman Jayapal.
Thank you to the gentlelady from California. And with respect to my colleague from Arizona, maybe you've never been in a court where they have minor children who are there. Well, I don't understand how you could say it's not happening, because I was in the court room at the hearing. I sat through the entire docket. It's called a kid's docket. And what's happening there is these kids who are 2 and 3 years old are hugging teddy bears and putting their head on the side of the pews, the benches, just trying to understand what's going on. And a judge is reading them their rights and saying, you have the right to be represented. I want to make sure you understand. You have the right to question the government. You have the right, blah, blah, blah. A kid, 3, 4 years old, is going to do that? That's not due process. That's a farce. And to my colleague from California's point, this article, this is an investigation by the New York Times. The department, dated November 16th, 2025, the Department of Homeland Security has diverted thousands of federal agents from their normal duties to focus on arresting undocumented immigrants, undermining a wide range of law enforcement operations in response to mounting pressure from President Trump. Homeland Security agents investigating sexual crimes against children have been redeployed to the immigrant crackdown for weeks at a time, hampering their pursuit of child predators. And federal efforts to combat human smuggling and sex trafficking have languished, with investigators reassigned to help staff deportation efforts. And it goes on to say that Homeland Security investigators worked approximately 33% fewer hours on child exploitation cases from February through April compared to their average in prior years. So please don't tell us that we don't care about kids who are sexually exploited or trafficked. That is ridiculous. And this bill makes no sense, because it's saying you gotta overload the system when there aren't any judges to take care of it. There's no resources invested, and it makes absolutely no sense.
Lady's time has expired.
I yield back.
Is there further discussion on the amendment? Seeing none, the question is on the amendment offered by the gentle lady from Washington. Those in favor say aye. Aye. Those opposed say no. No. The noes appear to have it.
Vote, please.
Roll call is requested. The clerk will call the roll.
Mr. Jordan? Mr. Isa, Mr. Biggs, Mr. McClintock.
No?
Mr. McClintock votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Fitzgerald? Mr. Klein? Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Nels votes no. Mr. Moore? Mr. Moore votes no. Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Grothman votes no. Mr. Knott? Mr. Knott votes no. Mr. Harris? Mr. Harris votes no. Mr. Onder? Mr. Schmidt? Mr. Schmidt votes no. Mr. Gill? Mr. Baumgardner? Mr. Raskin?
Aye.
Mr. Raskin votes aye. Mr. Nadler? Ms. Lofgren? Mr. Cohen? Mr. Johnson? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. McBath votes aye. Ms. Ross? Ms. Ross votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Goldman? Ms. Crockett? Mr. Van Drew, you're not recorded. Mr. Van Drew votes no. Mr. Correa votes aye. Mr. Fryer, you're not recorded. Mr. Fry votes no.
Clerk will report.
Mr. Chairman, there are 9 ayes and 10 noes.
The vote being 9 in the affirmative and 10 in the negative, the amendment is not adopted. Is there further discussion on the amendment, the nature of a substitute? Seeing none, the question is on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. Those in favor say aye. Those in favor say aye. Those opposed say no. In the opinion of the chair, the ayes have it. The amendment in the nature of a substitute is adopted. The question is on favorably reporting the bill as amended.
Could we have a roll call vote on that? Oh, that was an yes.
ANS. Question is on favorably reporting the bill as amended. Those in favor say aye. Aye. Those opposed say no. The ayes have it. The bill is ordered reported favorably to the House. And now, Mr. Raskin.
Recorded vote, please.
Recorded vote has been requested. Secretary, call the roll.
Mr. Jordan? Mr. Isa? Mr. Biggs? Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Fitzgerald? Mr. Klein? Mr. Gooden? Mr. Gooden votes yes. Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Nels votes yes. Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Grothman votes aye. Mr. Knott? Mr. Knott votes aye. Mr. Harris? Mr. Harris votes aye. Mr. Onder? Mr. Schmidt? Mr. Schmidt votes aye. Mr. Gill? Mr. Baumgartner? Mr. Raskin?
No.
Mr. Raskin votes no. Mr. Nadler? Ms. Lofgren? Mr. Cohen? Mr. Johnson? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. McBath votes no. Ms. Ross? Ms. Ross votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Garcia? Mr. Garcia votes no. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes no. Mr. Moskowitz? Mr. Goldman? Ms. Crockett? Mr. Tiffany? Mr. Tiffany votes aye. Mr. Onder? You're not recorded. Mr. Onder votes aye. Mr. Jordan? Mr. Jordan votes yes. Mr. Biggs, you're not recorded. Mr. Biggs votes yes. Mr. Fitzgerald votes yes.
Clerk will report.
Mr. Chairman, there are 14 ayes and 9 noes.
The vote being 14 in the affirmative and 9 in the negative, the bill is adopted. In order to be reported favorably to the House, members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes.